Thank you, Mr. Chairman. Let me be clear from the beginning. I'm not going to ask this witness any questions today. The reason is simple. The witness has already made it clear she has no intention of answering them directly. Instead, I'm going to ask a few basic moral questions to my colleague. Right or wrong, raping children? Wrong. Right or wrong, killing innocent citizens? Wrong. Right or wrong, using the presidency to enrich yourself? Wrong. Thank you. Because frankly, I doubt we would have received such clear answers from the witness before us. What's troubling is that this witness is a lawyer, yet seems unfamiliar with how testimony works. In a hearing, witnesses answer questions. They don't dodge them. They don't deflect. And when a witness refuses to answer directly, there's a term lawyers use for that: non-responsive. Now, I want to address the survivors in this room. You are not victims. You are survivors. And I want to thank you for showing more courage and moral clarity than many in positions of power today. Right now, our Department of Justice is failing in its leadership. Around the world, governments fall when corruption spreads unchecked. Yet here at home, we struggle to define basic right and wrong, not because it's partisan, but because accountability has become optional. Some members on the other side of the aisle have at least shown a willingness to question corruption when they see it. But instead of focusing on facts, this hearing has turned into attacks and deflection. In the witness's written testimony, she stated that her two primary goals upon taking office were to end the weaponization of justice, to return the department to its core mission. Yet critics argue that actions taken since then suggest the opposite. They point to investigations targeting journalists and political opponents, while serious criminal matters remain unresolved. There have been high-profile cases that failed to move forward, grand juries declining indictments, cases dismissed by judges, and investigations that didn't hold up in court. These outcomes raise legitimate questions about strategy, priorities, and leadership. Now, let's address the matter that continues to cast a long shadow: Jeffrey Epstein. This is not about speculation. It is about transparency. Public records show that Donald Trump's name appears in various documents related to Epstein. That alone does not prove wrongdoing. Being named in files is not the same as being charged with a crime. But the public deserves clarity. Photographs and flight logs confirm that Trump and Epstein were acquainted in the 1990s and early 2000s. Trump has stated publicly that he later cut ties with Epstein and banned him from Mar-a-Lago. However, the broader question remains: what exactly is in the full set of Epstein records, and why hasn't everything been made public? When discussing allegations involving powerful figures, facts matter. Due process matters. Transparency matters. Critics argue that the administration has not pushed hard enough for full disclosure. They also question other actions by the Department of Justice, from investigations into election processes to decisions regarding federal agents and internal oversight matters. Additionally, there are constitutional concerns raised about financial benefits or payments connected to executive power. The Constitution clearly states that the president receives only the salary fixed by law while in office. Any appearance of additional compensation would raise serious legal questions. Ultimately, this debate is about trust. Is the Department of Justice serving the Constitution, or serving a political figure? Is justice being applied evenly, or selectively? Now, where I continue. The issue here isn't just one disagreement in this hearing room. It's a pattern. A pattern of evasion, deflection, and selective outrage. When serious allegations are raised, whether about corruption, misconduct, or abuse of power, the response should not be to attack the questioner. It should be to confront the facts head-on. That's how accountability works. The American people don't care about party labels when they're struggling with rising costs, safety concerns, and distrust in institutions. They care about fairness. They care about truth. They care about whether justice applies to everyone equally. If the Department of Justice claims it is ending the weaponization of government, then the burden of proof lies in its actions. Transparency must replace secrecy. Equal enforcement must replace selective prosecution. And when it comes to the Epstein matter, this is not about conspiracy theories. It's about public confidence. Epstein's crimes were horrific. Survivors endured unimaginable trauma. Yet many still believe powerful individuals escaped scrutiny. That perception alone demands clarity. If the records are complete, release them. If investigations were thorough, explain them. If names appear but no wrongdoing was found, say so clearly and provide documentation. Justice hidden behind closed doors invites suspicion. Now, we also must be responsible in our language. Allegations are not convictions. Being named in documents does not equal criminal guilt. That distinction matters in a constitutional republic. Due process is not optional. It is foundational. But at the same time, proximity to criminal networks raises legitimate public interest questions. Leaders must be willing to address those questions without hostility or avoidance. This country was built on checks and balances. Congress has oversight authority for a reason. That authority is not an attack. It is a safeguard. And history will not judge this moment by who scored political points. It will judge whether institutions stood firm, whether leaders upheld the Constitution, and whether the rule of law was preserved without fear or favor. The American people deserve a justice system that is independent, impartial, and transparent. Not defensive. Not politicized. Not selective. Accountability is not a partisan demand, it is a constitutional one. Mr. Chairman, I yield. Let me leave this committee with something to think about. We are living in a moment where public trust in institutions is at historic lows. Confidence in Congress is low. Confidence in the Department of Justice is low. Confidence in the media is low. And when trust collapses, democracy doesn't collapse overnight, it erodes slowly. It erodes when transparency is delayed. It erodes when accountability feels selective. It erodes when powerful people appear insulated from consequences. That is why this conversation matters. Because if the American people begin to believe that there are two systems of justice, one for the connected and one for everyone else, then the very foundation of equal protection under the law begins to crack. This is not about revenge. It's not about scoring points. It's about restoring credibility. If this department truly wants to end the weaponization of justice, then show us consistency. Apply the same legal standards across the board. Investigate thoroughly, prosecute when warranted, and decline prosecution when evidence does not support it, but explain why. Silence breeds suspicion. Clarity builds confidence. And to those survivors sitting in this room, your presence is a reminder that this is not theoretical. The crimes tied to Jeffrey Epstein were not political abstractions. They were real. The pain was real. The trauma was real. The least this government can do is pursue the truth without fear or favoritism. No sealed file should remain sealed to protect reputations. No investigation should stall to protect power. No question should be dismissed simply because it makes someone uncomfortable. That is not how a constitutional republic functions. We swear an oath, not to a president, not to a party, not to a donor, but to the Constitution of the United States. That oath requires independence. It requires courage. And sometimes, it requires confronting allies as firmly as opponents. History does not remember titles. It remembers actions. It remembers who stood for transparency. It remembers who defended due process. And it remembers who protected the rule of law when it was inconvenient. If we fail to meet that standard, future generations will inherit weakened institutions and deeper divisions. But if we rise to it, if we choose fairness over favoritism, law over loyalty, truth over expediency, then this moment can become a turning point rather than a breaking point. So I urge this department, release what can be released. Explain what must remain confidential. Enforce the law equally. And restore faith not with words, but with action. Because justice, when applied evenly, does not divide a nation, it unites it. Mr. Chairman, now I yield.